Call People versus Austin Wright, 25 CR 1212. I'll take appearances. Ms. Raines.
Morning, Your Honor. Katie Raines on behalf of the people.
Thank you. And sir, if you'd say your full name, please.
I am the living, breathing man, Austin James Wright, Jr.
Mr. Wright, I will consider that you have entered your appearance. I will say that I acknowledge your non-conventional entry each time requested. I don't know if that's an attempt to lodge an attempt at a sovereign citizen entry to suggest that the court does not have jurisdiction over you. I will simply let you know if at any time I'm not aware of whether or not Austin Wright is present, I will have to issue a warrant for his arrest. I acknowledge your appearance, Mr. Wright. You have entered that appearance. There is no need for such a warrant this morning. Good morning to you and Ms. Raines. We're set for motions, and the reason the court set this motions, and it was an additional motion setting because the court wanted to make very clear to Mr. Wright that we were set for this motions and that the court wanted to clarify any motions filing deadline and the court's deadline for any plea cutoff. I acknowledge Mr. Wright's previous filing as it relates Mr. Wright, you filed a motion on August 4, 2025, and the court previously ruled on that. I acknowledge it just once again because the court recognizes that there have not been additional filings since then. The court recognizes the motion is...
Before we go any further, let's pause for a second, because what you're about to witness is a masterclass in how not to handle yourself in court. This is part one of a case that perfectly showcases a sovereign citizen mindset, colliding head-on with reality. On one side, you have the legal system, rules, procedure, deadlines, and consequences. On the other, you have a self-described living, breathing man who believes none of that applies to him. And here's the twist. This isn't some minor slap on the wrist case. We're talking 8 charges, 2 of them felonies, and a plea deal that most defense attorneys would beg their client to take.
All right. Are there just personal questions that you are contemplating in your mind, or the questions you wish to ask Ms. Raines or the court?
Questions I'd like to ask her.
All right.
On the record.
Well, I can't be part of your negotiations with...
It's not a negotiation.
Help me understand, for example, what you're...
trying to...
Mr. Wright, hold on. We're going to talk one at a time. And so help me understand the nature of the questions you'd like to ask Ms. Raines.
The nature and cause of this action.
Mr. Wright, have you received the discovery in this case? Those are the police reports.
Some of them I still have. I was called yesterday that there's more discovery that I have to pick up.
All right.
Today.
Ms. Raines, any record on Mr. Wright's obtaining the discovery in this case?
I actually don't have a note from our discovery department about whether he did pick up the initial batch. I can tell the court there are, I think, 2 new documents. One is a CV for a crime scene analyst who fired a weapon, and another is a criminal history for the traffic victim in the case. The rest of the reports should have been available to him, and so if he did pick up initial discovery, he should have all of those initial police reports.
All right. So, Mr. Wright, I'll let you speak with Ms. Raines. I'm not going to facilitate a discussion. I've given you an opportunity to file motions for me to entertain today. What I'm going...
I filed a motion, sir, and you set a hearing for it, and it was never heard, and...
This right here is a textbook sovereign citizen tactic, refusing to acknowledge the court authority by using alternative phrasing for identity. Living, breathing man is not magic. It's not a legal loophole, and it doesn't confuse the system. The judge immediately makes something very clear. You can say whatever you want, but the court can't confirm that Austin Wright is present. A warrant follows. That's not a threat, that's procedure. Judges deal with this language all the time, and notice how calmly this is shut down. No debate, no argument, just boundaries.
Does not have to go through a probable cause determination other than what's afforded by law. And when there's an opportunity for a preliminary hearing, your motion I read to be one in which there is challenge of probable cause. I previously denied that request based on your plea of not guilty, your challenge that there's insufficient law.
Look, I didn't plead not guilty.
Mr. Wright,
You entered that plea for me
Mr. Wright, you're interrupting me, sir.
from the bench.
Mr. Wright, you interrupted me and I'm going to finish talking. First of all, you asked me why I had not given you a hearing on that motion. That motion I ruled on. I don't find anything further that requires a presentation of evidence or further hearing. I gave you until November 12 to file any additional motions. None were filed. Today we're set for that motions hearing. Mr. Wright, I've given you that opportunity. As far as your not guilty plea, I'm not going to cause delay waiting on you to enter yourself a plea of not guilty. So I entered it on your behalf, which is the option preserving your constitutional rights if you do not enter a plea of guilty.
This is where the narrative shifts from legal confusion to perceived victimhood. Claiming you didn't receive a fair hearing is a common refrain. But notice what's actually happening. The judge explains that the motion was read, was ruled on, and did not require further hearing. That's not denial of rights. That's how motions work when they lack legal merit. Courts are not obligated to hold theatrical hearings just because someone demands one. And when Mr. Wright pivots to accusing everyone of financial interest, that's another sovereign trope, implying corruption instead of addressing substance. It's also strategic self-sabotage.
Not accept that offer, which you do not have to take, and you certainly do have a right to a trial, including a jury trial.
I don't accept the offer.
I understand. That is very clear, but I need to make sure as part of the record what the offer is, because I don't know what it is, and we're going to make a record for your benefit what that offer is that you're declining.
So this is a court of record.
Ms. Raines.
Yes, Your Honor. I will go through the original 8 charges first. As to both counts 1 and 2, they are both Class 5 felonies. They carry the possibility of up to 1 to 3 years in the Department of Corrections. There are also probation-eligible offenses. Count 3 is a traffic 2 offense that carries a possibility of jail from 10 to 90 days or a fine of $150 to $300 or both. Driving under the restraint is a traffic infraction A. It carries a possibility of a fine between $15 and $100. Count 5 is a traffic infraction B that carries the same possible penalty as count 4. Count 6 is also a traffic infraction B, so same possible penalties as the 2 previous there. No insurance is also it's a traffic 1, so it carries a possibility of jail from 10 days to 1 year or a fine of $300 to $1,000 or both fine and imprisonment. And count 8 is a traffic infraction A, which again carries a fine of no less than $15 but up to $100. The plea offer that was extended to Mr. Wright in this case contained 2 charges that he would have pled guilty to. One was a defective vehicle, which was a traffic infraction A, so a fine of between $15 and $100, as well as a plea to a misdemeanor 1, possession of an illegal weapon, which carries the possibility of up to 364 days in jail or up to a $1,000 fine or both. That plea would have required Mr. Wright to forfeit the weapons that law enforcement discovered during their investigation. And part of the agreement was that I would not have objected to a probationary sentence.
This exchange is crucial. When a defendant refuses to enter a plea, The court enters a not guilty plea on their behalf to protect constitutional rights. That's not misconduct. That's literally due process. And yet, Mr. Wright treats this as overreach rather than protection. The judge explains it clearly. No plea means delay, and courts don't stall because someone won't cooperate. This is where ideology collides with reality. You can reject the system philosophically all you want, but procedurally, the system keeps moving. And here's the irony. By entering the not guilty plea, the judge ensures he still gets a trial, still gets a jury, and still gets every safeguard.
And that you wish to rather proceed to trial on all counts 1 through 8.
I want to first know who the injured party is.
Mr. Wright, let me ask you this. Do you want to enter into this plea agreement or decline it and go to trial? Do you want to go to trial and not enter into that plea agreement? Because you answered yes, but I didn't know what you were answering yes to. I'm giving you a chance to clarify.
I do not want to enter into the plea agreement, and there could be financial interest in the process of this court, of each of the individuals in this court.
Mr. Wright.
That's a conflict of interest.
Mr. Wright, anything else, sir?
No. Does the prosecutor make any verified claim under penalty of perjury?
So to the extent that there was any request under Rule 97, the court does not self-recuse. The court does not recuse based on the oral request, suggesting that the court has any personal interest in the outcome of this matter. It does not. The court has no association with the parties or the outcome of this matter other than that of one of a professional association as disclosed in these proceedings. We currently are set for trial to begin January 14. It's a 3-day trial with all times beginning at 8 o'clock. Mr. Wright, I'll give you the same courtesy and opportunity, but I'll ask Ms. Raines first. Ms. Raines, anything further for the record on behalf of the people?
No, thank you.
Mr. Wright, there are certain things that you are saying that I don't fully understand. It may be that you have some questions of Ms. Raines that you may wish to discuss in person by way of email or otherwise. Mr. Wright, anything further, sir?
Is the prosecutor making a verified claim under the penalty of perjury?
The court recognizes the complaint and information that was filed May 28, 2025, supported with the affidavit in support of warrantless arrest that was filed May 23, 2025. The court has read that.
Now we're in the danger zone. This is where the abstract beliefs meet concrete consequences. 8 charges, 2 felonies with potential prison time, multiple traffic offenses, fines, jail exposure, probation eligibility, but also real risk. This is the moment any rational defendant pauses and recalculates. Because when charges are laid out like this, stripped of emotion and ideology, the math becomes obvious. Trials are gambles. Evidence doesn't care about personal theories of jurisdiction. And juries don't rule on YouTube logic. They rule on facts presented under oath.
You continue if you wish. An option that you have is to obtain counsel. There is time. Our jury trial is set for January 14 at 8 o'clock right back here. Counsel, what I would like to address are some pretrial issues that I think it may be best to just address now rather than conducting another appearance unnecessarily. In respect for Mr. Wright's time, and I recognize he has to then come into court every time we have a hearing. Ms. Raines may be in the vicinity already, so trying to consider Mr. Wright's availability as well. Let me print this out just briefly for my note-taking benefit, and then I'll address some things about trial and what that will look like. Mr. Wright, Ms. Raines, I'll have you out here shortly, and I also recognize because I went late on another matter, we got a late start, and that was no one's fault but mine. My apologies to you. So we're set for a 3-day trial. Either of you have any reason to believe that we'll need less time than that?
I think that's a safe estimate based on the nature of the issues that may arise during trial. But evidence-wise, I expect we could likely conclude evidence on day one, at least from the prosecution side.
Okay. Mr. Wright, any opinion that you wish to share?
Let's be absolutely clear. This plea deal is generous. 1 misdemeanor, 1 traffic infraction, no guaranteed jail time, probation friendly. The trade-off? Forfeiting weapons discovered during the investigation. That's it. Compare that to 2 felonies and the lifelong consequences that follow: employment, rights, sentencing exposure. Plea deals exist to mitigate risk. They are not admissions of moral defeat. They're legal strategy. Walking away from this isn't bravery. It's denial. Courts don't punish people for going to trial, but they also don't shield them from outcomes.
So let's talk about voir dire and jury selection. So voir dire, the process, we will have 25 minutes for voir dire with 2 minutes for replacement. And let me explain what that is, recognizing Mr. Wright is representing himself. So in the jury selection process, what we'll do is we'll have 1 alternate. We'll have 25 people in and in front of the jury box. Those people seated in seats 1 through 13 will be the presumptive jurors that will be selected. The person seated in seat 13 will be the alternate. No one is to inform any prospective jurors or jurors that there is an alternate or who that is. What we'll do is the court will conduct a voir dire, a jury selection, to make sure that there's no one who is by law not permitted to serve as a juror present. Both sides will have 25 minutes to ask questions of the prospective jurors. If there's anyone that is excused for cause, meaning that there is an extreme hardship or that they don't qualify, then there'll be need to replace those people from someone in the back of the courtroom, a prospective juror who has answered their summons. And so by replacement voir dire, that's what I'm talking about. And each side will have 2 minutes to ask questions. To be clear, jury selection will be based on, will be questions permitted will pertain to the appropriateness of a prospective juror to serve, their ability to follow the law, and to be objective. The court will limit opening statements to 15 minutes and closing arguments to 20 minutes. If anyone needs any parties, attorneys, witnesses, need any interpreters or Americans with Disability Act accommodations, I'm requiring that at least 21 days prior to trial that you notify me of that so I can
This line right here, "I do not consent," is the sovereign citizen mantra. and it fails every single time. Consent is not a prerequisite for jurisdiction. If it were, no criminal court would function. The judge's response is blunt because it has to be. The law doesn't need permission. At this point, the court has confirmed understanding, explained consequences, documented refusal, and preserved rights. That's the trifecta. From here on out, anything that happens is no longer confusion. It's choice. And choices have outcomes.
Ms. Raines, and I'll ask Mr. Wright the same question. Do you have a request as to the old or new reasonable doubt instruction?
The people would request the new reasonable doubt instruction.
Mr. Wright, do you have any position on that? The Supreme Court has recently updated the reasonable doubt instruction. There is an old one we refer to. There is the new one now. Do you have an opinion as to using the old or new one, which would ultimately be the instruction to the jury as to what reasonable doubt is?
I would have to understand what they are.
What I will do is order that the new is to be used, subject to Mr. Wright timely presenting to the court any request to the contrary. That will need to be filed at least 21 days prior to trial.
Where do I find this new definition?
So you can go to the court. Do you know about the Court Resource Center, Mr. Wright?
Mm-hmm.
I didn't understand if that was a yes or no.
Yes.
Yes. If you go there, while they can't give you legal advice, they may be able to point you in the direction of obtaining what that is.
You changed the definition of probable cause?
No. Ms. Raines, would you agree that this is instruction on Cole G? I've got E3. I
Yes,
was
Your
going to just print this out for Mr. Wright as a courtesy so that he could easily then see what the current one is and what the old one was. So, Mr. Wright, I'm going to print this out for you and give this to you so you can read this.
I appreciate that.
Yes, sir. I got to be careful not to give you legal advice, but this is part of the discussion.
It's in writing.
Mr. Wright, we'll ask the judicial assistant to give this to you. Thank you, Ms. Organ. Thank you, Mr. Wright. So 21 days before trial, if there's any objection to using the new, Mr. Wright, I'll receive any request. As far as live streaming, so Mr. Wright, one thing that we have going on right now.
This pre-trial hearing sets the stage for everything that follows. The judge establishes order. The prosecutor creates a clean and detailed record, and the defendant knowingly rejects a plea that could have drastically limited his exposure. There's no ambiguity here. The court ensured understanding. The offer was explained. The refusal was clear. What happens next will play out before a jury. Not ideology, not semantics, but evidence and testimony. And that's where belief systems face their toughest test.